many of you familiar with sort of the underlying case. Kingman's a county of 7,000 people. A guy who lives there named Seacat was an instructor at the Kansas Law Enforcement Training Center. He was married, he had 2 children. He is alleged to have shot his wife. I was talking to Jacqie over the noon hour. I can only imagine that if that in fact is what occurred, he then thought, oops, I shot my wife, and had not watched Law and Order enough to know that if you burn the house down, you can still figure out that somebody was shot. So he lit the house on fire, burned it down, was thoughtful enough to remove his children, and is charged with murder. It's not a death case, which, for the purpose of our state budget is probably a good thing, but my hunch is he's looking at a hard 390 or whatever the sentence is if you go down for this kind of charge. The district court judge in Kingman happens to be a guy I know very well and respect a great deal, Larry Solomon. I had a case, believe it or not, involving a trust where there was an argument every year where I had a case with Judge Solomon that went on for 14 years. He is a judge who's smart, who reads cases, does his own research. In any event, to digress for a moment, one thing that's changed in my lifetime, happily, is that in days of yore, even though the Miranda case and the Escobedo case were decided and you had a right to an attorney, a lot of times the courts would appoint sort of the attorney who was known to be the town alcoholic, who would spend about 30 minutes preparing for trial to defend these murder charges. This was pre-DNA. This accounts, frankly, for a lot of people being proven innocent years later. They just didn't get very good lawyers at the trial level. That is not true anymore. Mr. Seacat's represented by a guy named Val Wachtel that you and I are paying for, and paying him, decent hourly rate to defend Mr. Seacat. Mr. Wachtel is death eligible, which means that he's trained in these high-profile cases. And to cut to the chase, Val filed a motion to suppress certain evidence, and specifically evidence of uncharged other bad things that this Seacat allegedly did. And a motion to suppress, as you probably know, is a motion to say in advance of trial, I want an order telling the prosecution they cannot introduce evidence of this material. And he filed with it a motion to close the hearing on his motion to suppress the evidence. Judge Solomon made known that this motion was filed, and of course there were good reporters there who'd been following this case anyway, because there's sort of a open sealing order. I think at least 65 pleadings in that case have been sealed at the request of either the state or the defense. Frankly, each one of those could arguably be challenged. The biggest challenge in press law, frankly, these days is its cost, but I digress. There was a case decided 10 years ago called Wichita Eagle and Beacon versus Clark Owens, a judge in Sedgwick County, that stands for the idea that the press has the right to literally intervene in a criminal case to challenge the closure of a hearing. And Kansas is kind of unique in that regard. There's only a handful of states that literally give a news outlet the right to intervene. The 3 television stations in Wichita, the Hutchinson News and the Wichita Eagle, hired us to represent them, to move to intervene, a motion that Judge Solomon granted, and to challenge this motion to close this suppression hearing. And we wrote a good brief, and we argued the hell out of it. And Judge Solomon wrote a very thoughtful decision granting the defense motion. He noted, among other things, that Kingman County's present population is 7,500 people. It has a very small jury pool compared to most of the high-profile trials referred to in our papers. The court has lived in Kingman for 36 years, practiced law here for 13 years, and commencing his 24th year on the bench. Kingman County has only had one other murder case during that period. No one in the community knew the people in that case, and the media coverage was minimal. He then made his own findings that the coverage of the CCAT case was everywhere. There was no other way to characterize it. And then he went on to say this was fairly extraordinary, that he anticipated that he would have to summon between 10 and 20% of the potential jurors in the county to get a jury of 12 to try this guy. Long story short, he granted the motion. To fast forward, he made all the findings required by our Kansas Supreme Court in the case that's called Kansas City Star versus Fossey, which is that there was a clear and present danger to the fairness of the trial proceedings that could not be alleviated by any lesser measure than closing the hearing. And he was, the way a lawyer would say it, he was smart enough to write his decision in a way that tracked the Fossey decision. If you want to close a hearing, this is what you have to find to do it. And it was based primarily, I think, on the size of the county and his own experience in coffee shops, to be honest. Well, I don't say that. I want to say something before I go any further on that point. This is something that's changed about me over the years. I was a journalism major and a reporter before I went to law school. I've now been involved in fracases in the Carr Brothers case, the BTK case, and a lot of other sort of less well-known cases. I have to tell you, I have tremendous respect for all 3 points on the triangle in these high-profile cases, the defense, the prosecution, and the judges. These are really the legal major leagues, and these people are under tremendous stress and pressure to deliver a fair trial. The defendant wants an acquittal. That lawyer's supposed to be as zealous as he can possibly be to get his guy acquitted. The prosecution's supposed to represent all the people of the state, and the court's the referee. Mike may be better qualified to speak to this than me. I think he's saltier on U.S. Supreme Court cases, but I know that we've got lots and lots and lots of recitations of the notion that there is no first among equal in the Bill of Rights, that the Sixth Amendment right to a fair trial does not trump the First Amendment and its various rights. But I think what we inevitably find in these cases is that the court, there's kind of a disconnect, for lack of a better way to say it. If I'm going to make a mistake, I'm going to make a mistake by closing the hearing and not expose the state to the expense of another trial if we convict this guy, and then an appellate court says, you should have closed that hearing. Now, with due respect, it's a little bit irrational. But in our brief, I was counting the number of cases in our string site of cases where it's been argued that a case should be reversed because there was prejudicial publicity, and in the Kansas Court of Appeals and Kansas Supreme Court alone, we were up to about 30 decisions where that's never been found. And the argument I always make, and I lose track of time, so give me the ding-ding or whatever it is when I need to shut up, but the postscript to this, and it's a funny one, is that a month later, there was a motion in limine in that case, which is a little bit like a motion to suppress. It's a motion by the defense in advance of trial. Don't let this witness testify to XYZ. The testimony's inadmissible, and even mentioning it will taint the jury. In this case, it was a KBI agent who had investigated the fire. And Mr. Wachtel, again, very, very talented defense lawyer, feeling pretty sure of himself, filed a motion to close the hearing on the motion in limine. And of course, the thought is always, if we let the people know what went on in these suppression hearings or motions in limine, you know, the cat's out of the bag. So, you know, if the court rules, granted, you know, you can't talk about it that at trial. You folks will publish it anyway, so they'll already know what it is. And it's frankly, it's a reasonable argument. It's a good question. What happened in this particular case is, I think I said a moment ago something about the cost of media law. Our clients, we told them, you know, the size of Kingman County has not changed in the last month, and we're probably going to get the same outcome. So why don't you just let us prepare a written objection to this one and oppose the closure of the hearing, but we won't charge you to go out and argue it. So we didn't. And we won. So Lyndon Vicks and I have now decided that we're not going to argue any cases. It was a real confidence builder in our oral advocacy skills. But I don't know, I guess just in closing, the argument that I usually make, and I think, I hate to put it this way, I don't know if there's any state trial judges here, I have tremendous, as I said before, respect for the difficulty of the job of trying to keep these skids greased and let the prosecutor prosecute and the defense defend. But I think that ultimately these motions to close, even in a county like Kingman, where there's 7,000 people, many of whom can read and write, I think when you file a motion to close a hearing like this, you're really doing, what I tell trial judges is you're doing a disservice to the people of the county. Because anytime a case is tried, if you've ever been to a trial, the first thing you'll hear the judge say is, have you read any news accounts of this trial, and do you understand that you can't base your decision on the news accounts of this trial? And when you're picked as a juror, you have to take an oath, and you have to swear that I'll decide the case based solely on the evidence. Now, I know that litigants question whether jurors can truly do that. I've been doing this for 32 years, and I've probably tried 25 jury cases of my own and watched 25 more. And I've watched the trials in some of these criminal cases. I don't have a busy criminal practice, but I think by and large, juries almost always get it right. And I think by and large, jurors are in good faith. And a lot of times they'll surprise you after a trial when they tell you what they thought was good evidence and you didn't think it was, or something you thought was really important they ignored. But you're really doing them a disservice when you close hearings, assuming that they won't follow, they'll break their oath, that they won't follow the admonition, that they won't listen to the witnesses and decide the case based solely on the evidence. I've now ended up in the Portuguese Timor part of my remarks. I don't know how I got there, but I think I've answered as good as I can.
One quick question before we turn to Jacqie. What reason was given for the limine ruling?
Excellent point. And in fairness to Judge Solomon, it was a change that had occurred, and he tumbled to it. We mentioned it when the suppression hearing closure motion was heard. The trial was scheduled to take place at a point in time 3 months away. By the time a month later, when the in limine motion was heard, the lawyers had gotten together for the real trial date, which in these large cases, a lot of time, as you know, is a long time from the event. And it's now scheduled for trial in May or April. So it was going to be 6 months. And what Judge Solomon said, and we reminded him, there's a Kansas Supreme Court case called Bone, I believe, that says 3 months is probably plenty of time for readers to forget what they read in the newspaper. And he said that, well, even in Kingman, 6 months ought to be long enough, and so denied. So that was reason.
Thank you. Well, Jacqie, could we turn to you then and share with us your experience that would be instructive to our audience?
Well, first of all, I think that people watch CSI and NCIS for a reason. And they watch that because criminal law is good and juicy. And they don't watch it so that they can see the name of the defendant and the next scheduled hearing. They want more than that. They want to know how many times the victim was shot, whether or not there was a sexual assault before the killing, and they want to know the details that make their life more interesting, I think. So the challenge in your world is to get that information in a way that you can use it without taking anybody down with you. And as you probably know, prosecutors are especially restricted in what we can tell you. Who here has interviewed a prosecutor? Let me see your hands. And for those of you who've interviewed her, did she say, "I can't tell you that"? How many? All right. And then when you thought about hurting her, did you understand that there's a rule that she cannot blab the good and juicy stuff? And unfortunately, in a lot of ways, Rule 3.6, which is our license, I want to keep my law license. And I also want to be fair to the defendant. And so I can't tell you that this is the guy who's killed before, he's killed now, and if he's let out, he'll kill again. That's great headlines, but all we are really allowed to do is to tell you the boring stuff that you're not interested in. And so sometimes when a reporter will ask me, what was the cause of death? Or more importantly, I think, when a victim's family asks me, what was the cause of death? I can't tell them. And if you can imagine being the family members of somebody who's been murdered, for example, I can't tell them any more than I can tell the press. There's no family member exception. Unless it's public, I can't blab it. And so it's not just you getting screwed. It's the family members too, because they don't get to know it until time for some sort of evidentiary hearing, which is generally the preliminary hearing, oftentimes months after the offense. Now, if I could, I'd like to compare a couple of cases I have for you. I can't tell you everything, so don't try to drill it out of me. But I have 2 murder cases that are both pending now. And there's been some public hearings on them, so I can blab a little bit. One is the death of an 8-year-old girl. The other is the death of a recent high school graduate. And I compare these two because one is sealed and the other case is not. So, for example, in the case where the 8-year-old girl was kidnapped, beaten, raped, sodomized, and murdered, I can tell you that because it came out at what hearing? Preliminary hearing. I can't tell the family members before, and I couldn't have told you guys that before, but I can enunciate it now because I've already done so in court. But the other case where there's a murder of a high school student, I can't tell you one thing about that other than the titillating information of the next scheduled hearing. And the reason is because all of those filings have been sealed. Now, when I say filings, I'm talking about documents, motions that the defense has filed, that the state has filed, responses to each one. Who do you think asked for the sealing, the prosecution or the defense? Defense, sure, the defense. Because the argument is if we don't seal it, then the public will know. And if the public will know, then we can't get a fair trial. And if we can't get a fair trial, we don't have our constitutional rights. So in 22 years as a prosecutor, I've never asked anything to be sealed, and I've never asked anything to be closed. Sometimes the defense does, and they're doing that so that they can advance their client's presumption of innocence. But it's interesting that 2 terrible crimes, one is in the public view and the other really is not. So for prosecutors, while we feel for you, we know you want to make a story, and when you come and wait after a hearing and you ask us some questions, when we say, I'm sorry, I can't tell you, it's not because we're stinkers. It's because we want to get up tomorrow and practice law just like we did today. And I can also tell you, if it means anything, the family members are incensed sometimes that they can't be told. If a guy is interviewed by law enforcement and writes out a handwritten statement, I can show that handwritten statement to him before he testifies to refresh his memory, but he can't get a copy of it. If a victim, a surviving victim, gave a videotaped interview to law enforcement, I can show her that videotaped statement before she testifies to refresh her memory, but she can't get a copy of it. And Kansas is only one of 2 states that withholds its probable cause affidavits. So if you go not too far to the east in Missouri, is this east? Am I pointing east? What direction is that? That's what I said. If you go not too far to the east to Missouri, You can get a probable cause affidavit and every juicy detail is in there. But in Kansas, us and one other state, we can't release those. I know there's been attempts by the media to get those things released, and it will take a legislative fix. So when we're holding back on you, it's not because we don't love you. It's because we can't.
Question, go ahead.
Can I ask a question regarding that? Over the course of your career, you had mentioned that it's always the defense that requests any sort of hearing closure. In my career, whenever I've seen the defense ask for a closed hearing and the media brings in attorneys to object, I've never seen a prosecutor once take the side of the media. They generally just have no opinion. Why is that? Why doesn't the prosecution take the stand? Why doesn't the prosecution ever side with the public in regards to opening up these hearings?
Thank you for asking that question. Here's your answer. Because we look like we're trying to cheat the defendant from a fair trial if we do. The defense is saying, when they're trying to get everything withheld, that if the public knew about this, that the defendant cannot get a fair trial. If the prosecutor says, oh no, I want the citizens to know every sweet detail, it looks like we're trying to get the jury pool to make up their mind in advance. I can understand your position, but I would ask you to consider something a little bit differently. Rather than wondering why the prosecutor doesn't stick with the media when there's a request to close, ask yourself, does the prosecutor ever want the proceeding to be closed? Because we don't. I've never known anybody in my career, not just me, but any prosecutor, to close it. But we really risk appearing to be unfair if we say, no, these are details that everybody who might be a juror deserves to know about in advance.
Have you ever worked in or near Wichita? I worked in Wichita. I interviewed you in Kingman.
Well, if you've worked in or near Wichita, our retiring district attorney there is not averse to having an open hearing if it's a case in which she's going to be participating in the trial work. And I don't say that disrespectfully, but she's a political person and she's very astute politically. And she has sided with us in opposing closure motions by defendants. So I can't say that it's universally true that the...
It's pretty rare, though, wouldn't you say, that a prosecutor would side with...
The prosecutor, she doesn't need me to speak for her, but they do have conflicting ethical obligations. They do represent all the people of the state of Kansas, but they're also committed to, they have an ethical obligation to not do anything that would impede the defendant's right to a fair trial. Sometimes those collide. What happened in Kingman is that the state took no position. Now, sometimes that's frustrating, but there's an ethical basis for doing it, and but in more politicized settings, sometimes the district attorneys like hearings to be open. That's been my experience.
Just one thing real quick regarding the...
Gotta be on live.
I'll tell you later. I'll go. Go ahead. I thought that you made an excellent point in the briefing that you submitted in the limine hearing that you didn't attend regarding Kingman being 51st out of 105 counties, and that under the Judge Solomon's rules, court proceedings could be closed in over half the counties in Kansas if we were to take that. I thought that was an excellent point.
Thanks,
Mike. And Mike, you had a response while I take the mic back here. How about you did have a comment, didn't you?
Right. I just wanted to say in follow-up to what my colleagues have said that oftentimes when these closure orders are entered without a hearing and without notice to the press, it's not so much that the state is siding one way or the other, they're just acquiescing to what the defendant wants. And Jacqie has explained why they do that very eloquently, but it remains that there was no hearing. It was just an agreement of the parties.
I work in television, and I just recently moved here from Florida. And for a little bit, where cameras are allowed in the courtroom, and we don't really have much of a pool cam situation. But I'm curious how prosecutors feel when sometimes in television you need to get sound. If the prosecution can't talk on camera, how do you feel about you know, the sound bites from the defense and all those other different people.
What's the limit on the time on my answer?
Go ahead.
It is highly annoying when somebody comes forward and says, my man is innocent, he wouldn't have done a terrible thing like this, the prosecutor is railroading him, and she should be ashamed of herself. When in my file, I see that this is the third time that he's done it, and boy, would I love to say that. The problem is that we are supposed to rise above that, and we're really obligated to rise above that. So it's a mental note that the defense attorney is saying something, and most of them don't. But it's a mental note that the defense attorney is saying something that's, one, untrue, and two, cannot be responded to. Most of them really, though, are very good about sticking to the same rule about publicity. But since you said that you're in television, we had a trial in Shawnee County with 48 Hours was here. And the court was very accommodating to them. The 48 Hours drilled holes in the wall to put some shelves up there so that the cameras could be on there. I don't know of anybody who doesn't want the press there unless they're trying to defend that particular defendant and do their best job. And as a practical matter, I think everybody wants a defendant to have a fair trial. But it would be very nice if the rules were the same for both sides.
Is there another question? Yes.
I'm sure you heard.
Jacqie, this is really directed toward you, and I know I've covered some of the trials here in Shawnee County, and how comfortable or how much can a member of the media press before you get really upset? I mean, a lot of times you hear from an attorney, I can't talk to you, I don't want to say anything. Mm-hmm. I mean, when you really can say, hey, I know the law says that you can say this, or you can tell me maybe when the next hearing is. How
far do you push it?
Yeah.
I've never been annoyed by you. You've been a good girl every time I've talked to you. I can't imagine anybody from the press that I've been mad at. In fact, I give out my BlackBerry number, 785-633-4487. If somebody from the press wants to call, I'm happy to take the call. I almost always have very little information from them, which is a waste of their time. But they can call me if they want to. But I've never had somebody from the media be too aggressive. And I can't think of anybody that I have a complaint about.
Good for you. Is there another question then? All right, let's take up a couple of topics perhaps related to records. What if we have and any of the three of you, or all of you, are welcome to weigh in. I'll just pose some records-related questions and see what your experience may tell us about access to such records. Take the records about jurors. Questionnaires may be distributed, jurors fill them out. Have you had occasion to try to assist reporters in getting access to juror information? Has there been resistance? Do the courts typically allow it? What's your experience?
We did have that in the BTK case. There was Judge Wilbert was going to close the voir dire. There were lengthy written juror questionnaires, and then he was going to close the actual voir dire questioning of the jury, and we applied for and were granted a writ of mandamus by the Supreme Court on that, and we talked about that a little bit with Judge Solomon, actually. But it's not unlimited access to juror information. What they chided Judge Wilbert for, who again is a good, solid, very experienced Sedgwick County trial judge, is that he didn't go through what you need to do to go under the Fossey standards to close a hearing. And he kind of just decided in his head that there was going to be all this private information about the jurors and that he would sort of act unilaterally without giving notice to the press. Mike, I'm at a little bit of a handicap because I'm getting old. I can't remember exactly how it went after it was sent back by the Supreme Court. It was not unlimited press access to the written questionnaires of the prospective jurors, the actual in-court voir dire was open to the public. I'm fairly confident that we did not get unlimited access to the questionnaires, but it's gone stale in my mind, and I apologize for that.
Other, Jacqie or Mike, anything on that subject?
Well, I might just add that the Kansas Supreme Court rule is that we can't put the full date of birth, let's say, for example, of a child. If there's a crime committed against a child and the age of the victim is important, we cannot put their full date of birth in there. So we put only the year of their birth to sustain the burden of proof that it's a child. So there's a protection for the privacy rights of jurors and victims, and I think that's fair.
Then let's take, or unless you have a comment on this subject, Mike. Then what about the, let's go to the other end of the proceeding. What about something like an expungement hearing and the record of the expungement? Our clerk of court recently told me that this has become problematic. Some who have been convicted do succeed in getting an expungement of their record. It's taken out of the system or closed. And yet there are news accounts in news data banks around the country. There are those who have in some other form, some reference, historical reference to the fact of a conviction. And that information, especially in the digital age, gets out. So even if you've had an expungement, then you're still going to potentially be referred to as someone who was convicted. And if you were to receive a request, I'm thinking here of Mike and Bill in particular to start with, if a reporter were to say, well, I want to get access to an expungement record, or if you were defending a newspaper against a claim of defamation, say, and the only way you could defend would be to produce a record of a conviction, what would be your chances of actually getting to it, opening the expungement record? Is it something that the presumption of access applies to or not?
Well, I don't think there's any special exception for expungement type hearings. My newspapers do frequently get defamation type demands because the original conviction never is expunged from the internet. It's always there. And we don't alter our archives. Once it's there, it's there. And if they get it expunged, or it's a record of an arrest and they're acquitted, we don't change the fact. And that gets people angry. If we were to go to court to obtain underlying records where a case or a conviction has been expunged, we're not going to get it.
All right. And any quick comment from any of the others? Then how about the question of one that's on our list that we haven't yet gotten to, and time's running, and that is what about the subpoena that comes to a reporter? Or what about a subpoena to a news organization and a demand for disclosure of confidential source information? How should we tell our audience that the law applies in that case?
Well, we moved to quash those subpoenas in almost every case. A couple of years ago, the legislature enacted a statutory reporter's privilege. It's at KSA 60-480. We also rely in part upon the constitutional privilege, which does exist kind of parallel with the statutory privilege. So if you get a subpoena, you need to call me or call Bill or call somebody who knows to file a motion to quash it. Now, I'd have to say that those motions they meet with limited success because judges tend to find that reporters should testify just like any other witness, and so they find that the criteria to overcome the subpoena has been met. In a case from just last month in Topeka, which Jacqie knows about, the Ancico Stovall case, the defendant subpoenaed our reporter, Sherman Smith, who can talk more about this than I can probably, to find out the identity of a supposed juror who might have accessed the CJ Online website during the trial and might have commented upon the trial while the jury was deliberating. Now, if this was a juror who did in fact do that, there's serious problems. I mean, the defendant might get a new trial. The juror in question might be prosecuted for some sort of juror misconduct, I suppose. I don't know what the crime would have been. And so they want to find out from us, from CJ Online, who that juror is that made those comments, if it was a juror at all.
And who issued the subpoena for that? Which side?
Well, we got subpoenas from both sides. The prosecutor initiated what's called an inquisition, which is often called a one-man grand jury, and issued a subpoena from that. And as I said, the defendant issued a subpoena. Well, the defendant withdrew the subpoena. We went to a hearing, and it turned out that the defense counsel already had evidence of who this guy was. And he later testified on that evidence. We didn't fare that way in the inquisition subpoena. Judge Eberts issued an order just a week ago in which he overruled our privilege objection and ordered us to provide the identifying information of that poster, that commenter. A lot of people call it a blogger, but I don't think he's really a blogger. He was just commenting on a story. One of the criteria in these subpoena cases is that whoever's asking for the information can't obtain it from any other source. So they have to exhaust every other reasonable source for the information being sought. And our argument now is that the prosecutor should have gone to the defense attorney and asked him what he knew. I mean, wouldn't be privileged. The defense attorney talked to a witness and found out information that convinced him that that witness was in fact the juror. So that matter is still pending, but that's the brief that we filed on that case.
Jacqie, do you have any comments you could offer us on how whether there are any reservations on the part of prosecutors in issuing subpoenas to journalists in particular? Is there perhaps some reluctance to do it, or do you think does a prosecutor think of a journalist the same as any citizen who should contribute testimony?
No, I think a journalist has their own privilege in their contacts and in the information that they received, and so respecting that, we would go to a journalist or a journal or a news agency last. But if we are responsible for proving something beyond a reasonable doubt, we want the best evidence, and if we have to, we would, but I can't imagine that it happens very often. We're loath to do it.
Bill?
I was just going to say, we've seen a lot fewer subpoenas, frankly, since the SHIELD statute was enacted. And, turning to the subject of one of the other presentations, the rule that applies, this is one of these differences between federal and state court things. And one of the beauties and curses of our dual system is that in federal courts, you apply the substantive law of the state where the federal court is sitting, but you apply federal procedural law. The SHIELD statute is probably a procedural and not a substantive rule. Happily, for years in this federal district court and this federal circuit, we've had what's called the Silkwood versus Kerr-McGee test, which is that you cannot subpoena, not only a reporter, you cannot subpoena documentary filmmakers, even if they just sort of brand themselves one, authors. unless, as Mike was saying, they have information that's more than relevant. It must literally go to the heart of whatever the matter is in the litigation, and they must show that it's unavailable from any other source and that they looked. And then and only then will a subpoena ever be enforced in federal court against a journalist or this sort of enlarged group. Under the Shield statute, we don't have a lot of appellate decisions yet, but in Sedgwick County, I think it's had kind of a, frankly, a refreshing deterrent effect.